Good morning, everybody. Welcome to today's webinar, Is Your Local Government Whining About Your Winery? We're going to be exploring how New York State and local laws affect on-site activities at your winery. This webinar is being hosted today by the New York Wine and Grape Foundation, the New York State Farm Bureau, and the Long Island Farm Bureau. Today's webinar is being presented today by our friends at Schoeneck King, and we are very happy to have all of you with us today. We have a great group. My name is Valerie Venezia-Ross. I am the Director of Member Relations and Development at the New York Wine and Grape Foundation, and again, welcome. Before we officially kick off, I want to always take this opportunity to thank our members and certainly the members of the Farm Bureau for your involvement on all of our programs this year. We're really seeing some increased engagement and involvement, and webinars are certainly one of the things that people are enjoying. As far as an association, I think we can all safely say we're stronger together. So whether it's the Farm Bureau or the Wine and Grape Foundation, we really thank you for recognizing that and supporting that by being members. We really do appreciate it. And we're going to vow to work hard and return the favor to you by bringing you more valuable programming like this throughout the year. And so now kind of to the business at hand, today's webinar is important and timely. It's about an issue that's popping up all over New York State. So exploring how New York State and local laws are affecting on-site activities at your winery is being presented today by Jennifer Zinn and Brody Smith, who are members at Schoeneck King, as I mentioned. And before I introduce you to Jennifer and Brody, I did just want to touch base on a few quick housekeeping notes. So today, the webinar will be recorded, and you will have access to the workshop slides. Also, we're going to encourage you to ask questions today during the presentation. This format is a little bit different than the ones we used for the Wine and Grape Foundation webinars in the past, but you do have at the bottom of your screen, you're going to see a tab marked Q&A. To ask your questions, please click on that tab. It will open up and you can type your message into the form provided there. And without further ado, we're going to learn a little bit more about today's presenters from Schoeneck King. Jennifer Zinn is a business law attorney who engages in a diverse practice, including corporate and business law matters, real estate matters, liquor licensing, commercial lending, securities law, and immigration matters. Brody Smith's practice includes matters involving environmental law, eminent domain, the taxation of real property, land use, and municipal law. His clients have included automobile manufacturers, pharmaceutical companies, utilities, natural gas providers, mining companies, national retail chains, universities, and developers. He also represents local businesses and municipalities. And today, Jennifer and Brody will discuss the limits of power of municipalities to regulate wineries through local zoning and land use laws. Our topic is going to include the relationship between those laws, regulating wineries, and the New York Alcohol Beverage Control Law, the right to farm law, and other limitations to a town's zoning powers. So without any further ado, we want to thank you again for being here with us. And Jennifer, I think I'm handing this off to you.
Yes, thank you very much for that kind introduction. Welcome, everybody. Happy Friday morning. So as Val said, we're going to be talking today about what are some current local laws that are affecting wineries. What does the alcohol beverage control law require, and will that put any limits on the ability of a municipality to regulate wineries? I'll be covering that part. I do a lot of liquor licensing. What's the general rule regarding supremacy of state law over local law? And then is the right to farm law or any other legal provision going to limit a municipality's right to regulate wineries? So I'll go right into what does the New York State Liquor Authority require? So to some extent, that's going to depend on has a winery license or a farm winery license. I am imagining that a lot of the folks joining us right now probably have a farm winery license. Whether you have a winery or farm winery, you probably recall at the time you applied that classification is going to be determined by your location, the type of wine you produce, and the quantity you produce. But most wineries in New York, if they can qualify as a farm winery, try to qualify as a farm winery. So I'm going to focus on that a bit as we sort of go through these liquor authority requirements. So if you have a farm winery license, as far as the New York State liquor go, your liquor license allows you to do the following: produce up to 250,000 gallons a year of wine made exclusively from New York State grown grapes or other fruits. It's not just the 75% rule that you may have seen in other contexts, it's exclusively. Does that mean you have to grow all of those grapes yourself? No, but they do have to be New York State grown. And you can also produce cider with no limit. A lot of you, if you are producing cider, may be making cider exclusively from New York State grown fruits, so that you can qualify as the New York State labeled cider. But if you're a farm winery, you're actually not required to. You can get ingredients, you can get apple from other places. So to qualify for a farm winery license, you have to be any place or premises located on a farm in New York State in which wine is manufactured or sold. So what is the liquor authority considered to be a farm? Now, as we get into some of the rules later on, that Brody may cover, the rules, right to farm law and other statutes are different. But as far as the liquor authority is concerned, you qualify as a farm if the land, buildings, and equipment are used to produce, prepare, and market crops, livestock, and livestock products as a commercial enterprise. Your farm can consist of one or more parcels of owned or rented land, which parcels may be contiguous or non-contiguous to each other. So it's a pretty broad definition. You can qualify as a farm for liquor licensing purposes if you don't grow all your grapes yourself, if you grow things other than grapes, if you're using it for livestock, if you rent it, if you own it. It's pretty broad. As long as you are producing, preparing, and marketing crops, livestock, or livestock products as a commercial enterprise. So, as I mentioned, if you have that farm winery license, you do have to use New York State ingredients. Your wine has to be made exclusively from New York State grown grapes or other fruits or other agricultural products grown or produced in New York State. As I mentioned, that doesn't necessarily mean you have to grow them. You can have arrangements with other wineries within the state, other farms within the state for your ingredients, but you do have to be using them in making the wine. And I just threw this in as a brief note. We do get this question from time to time. Is there any exception from having to use those New York State grown ingredients if you are a New York farm winery? It's a hard standard to meet. Under certain circumstances, if there's a natural disaster, act of God, or continued adverse weather condition that's destroyed no less than 40% of a specific grape varietal grown and produced in New York State, there's a process you can go through for an exemption to use grapes grown outside of New York State, but it doesn't happen very often that you can meet that standard. So now I just want to get into a little bit about how does the municipality get involved from a New York State liquor licensing perspective? What is their role in you getting a liquor license and you keeping your liquor license? The SLA application for manufacturing license, that includes your farm winery license, requires that you notify your municipality or community board. The community boards are in New York City. Outside of New York City, it's going to be your local town, city clerk. And you have to notify them at least 30 days prior to filing an application with the liquor authority. Under certain circumstances, you might also have to notify your municipality if you're making significant changes, alterations. If you're in New York City, significant corporate changes, you're selling your winery, a class change, you want to move from a winery and you're turning into a bar, for example, and removal if you are moving to a new location. In all of those circumstances, you're going to have to notify the municipality of your intent to file this application with the liquor authority. And then you have to wait 30 days unless the municipality waives that for you. And during that 30 days, the municipality does have the right to object. They can express an opinion for or against granting the liquor authority granting your application. The law says any such opinion will be deemed a part of the record upon which the liquor authority makes its determination. So if your municipality objects to your application for a farm winery, does that mean you won't get it? Not necessarily, but the liquor authority does take that into very serious consideration if the town is objecting to your application. It's not automatic that they will accept or reject what the town has said. but they do take it pretty seriously. In addition, once you've gotten your liquor license, even if you're not applying to the liquor authority for anything, for any changes, for any license, the municipality can still be involved. They may, there's a provision in the law allowing the municipality to report certain things to the liquor authority. And if they do so frequently, within 6 times within 60 days, it's presumed that these things have occurred. That 6 times within 60 days does not happen very often, but I can tell you that about half of the disciplinary cases I handle with the liquor authority are from a report from the municipality. A lot of times it's from the police department if there's been a incident there, or a disorderly call, or there's been a noise complaint. A lot of times that will get reported to the liquor authority, and that's when it comes to my desk. Most of the other half is when a competitor makes the complaint to the liquor authority. But about half of them is the municipality, generally the police department, reporting an incident or a noise complaint, that sort of thing. And if it happens frequently enough, the liquor authority is going to presume that it's occurred. So I'm also just going to talk briefly about this local option that is contained in the New York State Alcohol Beverage Control Law. That is a provision in law, and it's been around for a long time, but it is still on the books, that allows any town, municipality, city to have a vote. They would do it 60 days, between 60 and 75 days before the general election. Folks can get a petition together. It has to be signed by the electors, 25% of the votes, and it would put this on the ballot, and it would allow the town residents or city residents to vote to allow or disallow or limit these things. So I've listed them there: taverns, restaurants, hotels serving alcohol, package stores, that's generally your liquor and wine store, ballparks. Now the local option law does not specifically mention wineries, but the reason I'm including it here is to just show you the deference that the New York State Liquor Authority and the Alcohol Beverage Control Law have to the municipality and its wishes. So the last list that the Liquor Authority put out of dry towns was actually from 2016, so this might be a little out of date. But at that time, there were 8 totally dry towns and 37 partially dry towns where only certain kinds of liquor service, either on-premises or off-premises, is allowed. So if that local option has been passed, it's a dry town, the Liquor Authority does not have the ability to issue that kind of liquor license. Regardless of whether they want to or not, they're not able to if this has happened, if this vote has happened. So once you have a liquor license, there's there's been a lot of rulings and things like that with the Liquor Authority about what is it? Is it a contractual right? Is it property? How should it be treated? How can you lose it? Are you entitled to receive it when you file your application? And the Liquor Authority's policy has always been that a liquor license is a privilege and not a right. And that's important because courts have upheld that. So if the Liquor Authority turns you down, it's a pretty high standard for a court to reverse that. It also means that it's a bit easier for the Liquor Authority to impose sanctions on you or take away your license because it's not considered a right. There are licensees that have argued that it is having a liquor license is the equivalent of having a contract with the state, but that's not been supported by court decisions. So it is treated as a privilege and not a right. Now, the ABC law, the Alcohol Beverage Control Law, and the Liquor Authority's guidance also is very clear that licensees, whether they're wineries, bars, hotels, whatever it might be, are required to comply with local and state laws. The guidance says if you're an on-premises licensee, and a lot of wineries are going to have that on-premises capacity, right? You're going to be doing tastings, you may be having events, etc. So you'd be expected to comply with all local and state laws and regulations governing the operation of your business. This includes health, fire, and building codes, If you're in violation of a state or local law or regulation, you could face disciplinary action by the SLA, as well as the agency that enforces the particular provision. And I have had this happen. I've had towns go to the liquor authority and say, such and such is not complying with the building codes, they've got violations, they have these issues. And the liquor authority will get involved in the sense that they will charge you with a violation of their laws. At the same time, the town might be pursuing you for other violations. So that begs the question of, can a local law, their zoning, their building codes, et cetera, the alcohol beverage control law, which is a state law? So we'll go through just really quickly some general rules regarding supremacy of state law. So in general, local governments only have the lawmaking powers that the state legislature has given them. This includes the power to adopt local laws that are not inconsistent with the state constitution or any general state law. So that generally, state law will trump local law. However, localities do have the ability to pass certain laws, as long as it's not inconsistent with the state constitution or any general state law. So the state legislature gave this power to the municipalities through the Municipal Home Rule Law. And one of the things that was granted to the municipalities through that law was the power to pass zoning regulations. That we see is a frequent way that towns and cities may try to impact or control what the winery is doing, is using those zoning regulations. Not always, but that is a common one. So state law can prohibit or preempt local law in two ways. One, if the local law directly conflicts with, the second way is if the local law is in a field that the state legislature has assumed full regulatory responsibility for, and that can be expressed or implied. So courts have generally found that the state alcohol beverage control law impliedly preempts in that field. So a locality would have trouble passing or getting upheld a law that was very specific to alcohol sales, because the ABC law and the liquor authority are in charge of that. However, wanted to talk a little bit about this case from the highest New York State court, the Court of Appeals, that was in 2001. And it dealt with New York City zoning regulations regarding adult establishments. And this is a frequently cited case on this issue, so I apologize in advance. I know it's about adult establishments. We won't get into that too much, but the case was brought to the highest court in New York State by some adult establishments that had liquor licenses, had operated at their locations for years, held liquor licenses, had applied to the New York State Liquor Authority. Licenses were complying with what the New York State Liquor Authority said they had to do to keep their liquor license as an adult establishment, and there are some specific rules for that. Then New York City passed these zoning regulations that affected their ability to operate at their locations. So the local businesses filed suit. They argued that their liquor licenses were improperly impacted by New York City's zoning change. The city had implemented these zoning changes to require all adult establishments to be located only within specific districts of the city. And of course, our plaintiffs here were not located within those specific areas. And there's a lot of discussion in the court case about why did the city pass these zoning rules. And there's a discussion, they were trying to address what they saw as secondary impacts from these adult establishments, crime, noise, those sorts of things. So the Court of Appeals held that it upheld the zoning resolutions because it found that they applied to all businesses and did not specifically regulate alcohol. So these rules said any adult establishment, whether it has a liquor license or it doesn't, has to be within a certain zone. And the court held one of the most significant functions of a local government is to foster productive land use by enacting zoning ordinances. Local laws of general application, which are aimed at legitimate concerns of local government, will not be preempted if their enforcement only incidentally infringes on a preempted field. So here the court found that the zoning rules imposed, the new rules imposed by the City of New York, only incidentally infringed on alcohol because they applied to all adult establishments, whether they were serving alcohol or not, and they were enacted for legitimate local concerns such as noise, crime, etc. So I'll also mention briefly one other case is not, it's not all the way through. I wouldn't rely on it, but I did want to point that out to let you know that there are some other cases that are still working their way through the system. The Supreme Court of Suffolk County did issue an unofficial and unpublished decision back in July. And in that case, the winery had filed suit to, the town filed suit against the winery to get them to stop using certain of their recently constructed buildings because they hadn't gotten building permits and certificates of occupancy. The town had a law requiring a town permit for a special event. They wanted the winery to get all those permits for their special events, wanted them to stop having amplified music, and also had some concerns about a restaurant on the winery grounds that they had not gone back to the town for an amended site plan approval for. So the Supreme Court case, I mentioned this is probably going to be still working its way through the different levels of the courts, but at the lower court did find that the winery had to go back to the planning board to determine whether the amended site plan approval was needed, and that it did have to go back to the town to get its building permits and its certificates of occupancy. Regardless of the fact that the winery argued it should not have to go back to the town, should not have to get these permits because it was should be protected as farm operations under the right to farm law, but the court disagreed. So that is my portion. I'm actually going to pass it over to Brody now to talk a little bit more about the right to farm law and some other rules about preemption and powers of the municipalities.
Thanks, Jen. So I'm going to focus more on land use and the right to farm law and how the ag and markets right to farm law interacts with local land use regulations. The first slide talks about how counties, towns, and villages in New York have broad powers to enact laws and govern their own affairs. However, state laws impose certain restrictions on local government authority. So the right to farm law is an example of that. Jen talked a bit about preemption, about occupying a field, and we've all heard about different examples of it in the news and instances separate and apart from wineries. For example, there was contentious cases several years ago about the preemption of the field of the state with regard to aggregate mining, surface mining, with the New York State mining law. And there was a series of cases, and the court ultimately decided that the state regulation did occupy the field in that instance, and certain local zoning regulations were struck down, but others remained. Same sort of thing played out with regard to hydrofracking. That was obviously big news. To what degree does a state law occupy the field is going to be unique to the wording of each of those statutes. Sort of a rule of thumb when thinking about these sort of issues is oftentimes the DEC or in this case ag and markets or whatever kind of law it is, they'll set regulations about the manner by which a certain activity can take place. The towns generally have, under their zoning authority, the ability to dictate the location where those things take place. So for example, the outcome of the hydrofracking litigation, that was the Dryden case that was national news, was that the town, aspects of that law were struck down. The town couldn't regulate the manner by which someone would mine, but or drop a well, but they could influence the place that activity was allowed to occur based on the zoning regulations. So moving into some more specific ag and markets issues, Section 305A of the Ag and Markets Law is the operable statute that occupies the field in the subject matter that we're talking about today. So I'm not going to read a lot of laws to you, but I'm going to read this one because it's going to come up over and over again. Local governments, when exercising their power to enact and administer comprehensive plans and local laws, ordinances, rules, or regulations, shall exercise these powers in such a manner as may realize the policy and goals set forth in this article, and shall not unreasonably restrict or regulate farm operations within agricultural districts in contravention of the purpose of this article, unless it can be shown that the public health or safety is threatened. There's a couple key words in there where there's been opinions written, orders from ag and markets, and decisions from judges. The first one is unreasonably. Obviously, that's something that's been litigated, and that's an operative word, because impliedly from the language of the law is that there are certain things that local governments can do, but the restrictions that they place can't unreasonably restrict the farm operation. Farm operation is a term of art that's defined in the ag and markets law, and I'll talk a lot more about that, what specifically that means. It's important to note that this protection applies to farms within an ag district. That's a district created by the county body appointed to do so, and doesn't necessarily apply to all farms. And then you also see at the end of the law, there's the exception to the exception, right? That's the one that's always sometimes the most important. And that's where there are instances where something does unreasonably restrict agriculture, but the department says if it's necessary for public safety and the town can articulate a real public safety concern and demonstrate it through evidence and testimony in a credible way that convinces a judge, then the judge may allow that restriction. Now, there are lots of cases where a town or village generically argue that certain regulations are required for public safety, but that testimony isn't deemed credible by the judge, and it's just seen as a straw man for an excuse to try to get around the ag and markets law. So what happens if the town, I want to move from the abstract to the concrete now. So what should you do if the town is enacting a law that would restrict your business as a winery? There are several steps set forth by ag and markets. There's a lot of pretty succinct guidance documents that they provide. I'm going to go over the highlights of a few of them just to familiarize you with the process. I'm going to stop a couple times in the middle of that process to talk about the substance of it, but let's begin with the procedure. What steps could you take? The first step you could take would be informal contact with ag and markets. Questions concerning the impacts of local laws and ordinance on farm structures or farming practices, says ag and markets, are more easily solved at the drafting stage. So the first thing to do would be to contact ag and markets. Ag and markets reaches out to the municipality and tries to broker some sort of compromise, tries to modify the law that it won't violate Section 305A that we just talked about. There's an informal response that will come from the Department of Agriculture and Markets. They'll provide informal, non-binding responses to these kinds of inquiries. Similarly, a farmer or other affected party in an agricultural district may seek the department and the market's informal opinion on proposed or existing laws or ordinances without filing a formal complaint. So it makes sense to reach out to your local representatives from the department if there is a law that is on your radar that would potentially unreasonably restrict farm operations. Now, what are the type of laws that municipalities can institute, and why are they particularly problematic for farms? Well, one thing that's common to zoning is the requirement that the primary use be the only use on a property. Obviously, farm operations have a lot of diverse uses. So if a local zoning code is passed without keeping that in mind, then that can cause problems for farms because your principal use or structure may not be the only use. It's many zoning devices that are unable to distinguish between on-farm structures as part of a farm operation from the same building when it is in an independent or freestanding use, so non-agricultural contexts. Yard requirements. You'll see in zoning that there are yard requirements that are designed to avoid, concentration, front yard setbacks, side yard, rear yard, that maintain adequate space for light and air and open space. Well, those setback requirements, which may make perfect sense in a suburban housing tract, may really restrict in an unintentional way farm operations. Also, sometimes there are very narrow definitions of a farm. Some municipalities will define what a farm is, not setting aside the agriculture and markets definition and creating their own and having it be very narrow and only allow you to engage in certain activities instead of the range of activities that you'd otherwise be able to engage in. So local governments may run afoul of the letter and intent of the agricultural districts law by limiting the type and intensity of agricultural uses in their communities and by narrowly defining the word farm. Comprehensive planning is so important. I think sometimes it's easy to think of a comprehensive plan as sort of this vague document that's off to the side and it's not as important as zoning. In a lot of ways, in some ways that's true, and zoning laws are more concrete. It's more clear whether you're running afoul of them or not. But the zoning law should be written according to a comprehensive plan. So when you look at the preparation, adoption, administration of a comprehensive plan, that is an area that it's important for farmers to be involved in, because that zoning regulation will proceed from the plan. So whatever zoning regulations are passed, amendments to the zoning law, they must be done in accordance with the comprehensive plan. If they're not, they may be subject to legal challenge. So if there's a law that you're opposing, it makes sense to, when you participate in that process, to have a good understanding of the comprehensive plan, because zoning amendments should not be in conflict with the comprehensive plan. And many times comprehensive plans will emphasize the importance of agriculture, and there could be some useful things to pull from that when you're getting up and speaking for or against an amendment to the zoning law. Town Law Section 272A talks about the comprehensive planning, and it talks about agriculture in particular. For a town containing all or part of an agricultural district or lands receiving agricultural assessments within its jurisdiction, the Ag and Markets Law relating to the enactment and administration of local laws, ordinance, or regulations, all that is listed in the comp plan law, that should be listed as part of the comp plan where the districts are, and that should be taken into account. It also says that towns and villages should exercise their powers to enact local laws, ordinance, rules, and regulations that apply to farm operations in an agriculture district in a manner that does not unreasonably restrict or regulate farm operations in contravention of the purposes of the Agriculture and Markets Law. And then you see the public safety language again. Now that is lifted from the Ag and Markets Law, but you see it's written again in the town law and the village law, very similar language when talking about enacting local laws and comprehensive planning. In general, the construction of on-farm buildings and use of land for agricultural purposes should not be subject to site plan review and special permits or non-conforming use requirements when they're within an agricultural district. Now, there's exceptions to that, but that is the position that's been taken in guidance put out by Ag and Markets. But they also provide for some exceptions to that. And it's not binding. I'll get into the process where Ag and Markets will interact in a moment, but I want to make sure everybody understands what a special permit is first. So a special permit is an activity that is permitted in a zone, but not as of right. So an area could be zoned residential, and you don't need to get any kind of special permit. You just apply for your building permit, and then you can build a single-family residence. But there are other activities. The most obvious one, I think one of the reasons the concept of a special permit was initially invented, imagine a gas station. Well, you have to have gas stations in a town, but they're particularly disruptive, and the law doesn't allow you to have it just anywhere in a commercial district. It'll say, gas stations or drive-throughs will be permitted in a commercial district, but only with the issuance of a special use permit. So the special use permit is a heightened level of review for certain activities the towns view to be fraught with more difficulties than other uses which might be permitted as of right without going through that process. So agricultural uses in an agricultural district should not be viewed as special uses. You shouldn't have to get a special use permit to have a farm in an agricultural district. And that's a position that the Ag and Markets has taken strongly, but oftentimes in many towns, you see the attempt to impose special use permit requirements. Site plans. Pretty much any sort of commercial or industrial development in general requires a site plan. Site plans and special permit review can be expensive, though. You have to retain professional assistants, that'd be an engineer or an architect, to do the site plan and to shepherd you through the process. Sometimes you need a lawyer. The lengthy approval process can be burdensome, it can be slow and inefficient. So the State Ag and Markets has taken the position that generally farm operations should not be subject to site plan review requirements, though they propose a compromise position where municipalities can adopt a streamlined site plan review process. The department has developed a model streamlined site plan review process which towns can adopt, and the way that it is streamlined is it's faster. The department uses local governments to take into account the size and nature of particular agricultural activities, including construction of farm structures, when setting and administering site plan requirements. The review process, as outlined, should generally not require professional assistance. So where generally speaking, anytime you have a drawing, it has to be signed by an architect or an engineer. The Ag and Market suggests that in the streamlined process, farms not be subject to that requirement, number one, and that there be an expedited schedule to allow farms to complete that process in 45 days. State law for site plans usually requires a town to make a decision within 90 days. And that obviously can be very difficult for farms where those time restrictions could interfere with your growing season. Also, site plan review often in general includes public hearings, but in the proposed streamlined site plan review by Ag and Markets, they recommend no public hearings. There are concerns with being subject to site plan review. There are minimum and maximum dimension requirements. There are lot size requirements. There are setbacks, sign limitations, maximum lot coverage requirements, screening and buffers. These are all the factors that a planning board will go and consider when deciding whether or not to issue site plan approval, and they can be problematic for farm operations. Seeker also is an important consideration if you find yourself in a position where you're applying for a special use permit or site plan. Standard agricultural farm management practices should be considered type 2 under Seeker. What does that mean? Seeker is the portion of your special use permit or site plan review process where the board that's issuing you the approval must consider impacts on the environment. And as part of that law, there's a type 1 list, things that are assumed to have a larger impact on the environment, which will require more rigorous review and the preparation of an environmental impact statement. And then there's a list of type 2 activities, which are assumed not to have a significant impact on the environment. And if you fall under the type 2 list, then it alleviates your requirement to comply with all the many regulatory ins and outs of Seeker. It exempts you out of it. So if you are engaged in an activity or land use activity that is consistent with, I quote, generally accepted principles of farming, close quote, then you should be considered a type 2 activity and you shouldn't have to comply with all the requirements of Seeker. Building code. We all know that the building code exempts farm buildings largely from a lot of its requirements. That we could have a whole hour course on that, so I just want to touch on that. But the newly revised Uniform State Building Code is consistent with that. But in order to have that exemption, there can't be human habitation as defined in the building code within a structure. So you can't have a barn with an apartment above it and expect for it to be exempt from building codes. Human habitation is the key legal concept that gets weighed as to whether or not you're going to keep your exemption from the building code requirements. As a side note, many towns do require you to apply for a building permit, even if you're going to be exempt from all the different permitting requirements under the state code. That's a way to keep track. The reason municipalities do that, and a lot of times they won't even charge you a fee, they can exempt agricultural operations from paying that fee. The reason that that's done is they want to keep track of what's being constructed in the town. That information is sent along to the assessor, and it's probably in everyone's interest that there be an accurate accounting of what structures are there. In the event that you for whatever reason, cease to use that structure for agricultural purposes, then the assessors obviously going to want to know that it's there, and may seek to try to change your tax exempt status for that. There is the building code includes an exemption for agricultural buildings used solely in raising, growing, and the storage of agricultural products by a farmer. So again, that interplay with the human habitation definition is relevant. So I've just talked about all the different things that may be problematic for your farm: site plan review, special use permits. We talked initially about, when these laws are proposed, that informal contact with ag and markets. But what happens if none of that works? The next step is a written request for review to state ag and markets. And there's certain things that you have to include in your written formal request if you want ag and markets to review a local law that you believe is unreasonably restricting a farm operation. So you have to provide, I'll go through them quickly, but you have to provide the location of your farm operation, identify where it's located. There has to be a brief description of the affected farm operation, the size of the farm, years in operation, that sort of thing. A description of the specific farm structures or practices involved and how they're affected, a copy of the complete local law and ordinance that's at issue, a listing of involved parties who can be contacted for further information. There's certain factors that the state agency will consider when deciding whether or not to issue a decision and what action, if any, to take. Section 305A only applies to farm operations in an agricultural district. So for those of you who are unfamiliar, just very briefly, these agricultural districts, there's a process by which you can apply to be included in one, and they're administered on the county level. So the county legislature will appoint a committee that will propose additions or deletions from the agricultural districts for a county, and then it'll go to the state legislature for approval. Also, it has to be a farm operation. We talked about that initially when we looked at the law. So land and on-farm buildings, equipment, manure, processing, and handling facilities and practices which contribute to the production, preparation, and marketing of crops are all considered part of a farm operation. Some of you may be familiar. The biggest case on this particular issue was the town of Lysander versus Hafner, and that is a 2001 Court of Appeals case. That's the highest court in New York State. And the issue that was litigated in that case was whether or not temporary mobile homes, which were placed on a farm in order to house migrant workers regulated by the town. And the court ultimately decided that they could not, because they were, and referring back to the language on the slide there, an on-farm building that was contributed to the production, preparation, and marketing of crops. So that the local mobile home law in the town of Lysander couldn't be used to remove those buildings because they were on-farm buildings. Now that sort of pushed the definition of on-farm buildings, a couple steps further. There was a lot of uncertainty prior to that case, how far that would be taken, whether it applied only to barns that store equipment and crops, or would it be further? And the court did extend it further. Crops include a lot of different things, but just for our conversation today, it includes apples, peaches, grapes, cherries, and berries, according to the Agriculture and Markets Law. The department considers agricultural commodities produced on farm to include any products that may have been produced by a farmer on his or her farm operation, but that could include other parcels that aren't contiguous. And that's something that a lot of people misunderstand. A farm, in quotes, isn't necessarily a square plot of land. It could include other properties owned in other parts of the town or even the county. Processing, distillation, brewing, fermentation activity in on-farm buildings and equipment which is needed to do that is all considered part of a farm operation. And so that includes wineries, grapes, other kinds of breweries, distilleries. The wine must be composed of 51% or more of on-farm produced grapes or other fruits. There's a ramp-up period. This doesn't have to be in place year one, but ultimately you have to get there. There's some exceptions for startups. If grapes or fruits are imported as whole fruit, then gross weight of on-farm produced grapes must be at least 51% of the finished wine. If juice is imported, then the gross volume of the juice from on-farm produced grapes or fruit must be at least 51% of the finished wine. While an alcoholic beverage may be produced at the farm entirely from off-farm agricultural crops, at least 51% of the agricultural crops used to produce all of the farm's alcoholic beverages on an annual basis must be from the farm's own production. So you could have a bottle of wine that's composed completely of grapes that are grown elsewhere, but you're looking at the total volume of all your products on the property when you're making that calculation. Obviously, it becomes very important to keep records, and that's a hard thing, to overemphasize when talking about this if you're ever to be audited. In terms of wine-related products, those are also a part of a farm operation. So there's all those other things you sell in the tasting room, right? That's the corkscrews, the cookies, the muffins, the cheese, all that sort of thing. Those are all considered wine-related products by ag and markets. But you have to keep sufficient records to make sure that the requirements are met in terms of gross sales. It becomes a question: is it incidental, or are you really in the cheese business and you happen to grow a little bit of wine? You have to keep records so you can prove that the other proposition is true. Marketing activities are permissible: wedding receptions, parties, and special events. These activities are evaluated on a case-by-case basis to see if it's really a wedding venue that happens to grow a little bit of wine, or if you're primarily a winery and you use these events to market the wine. There's a test for activities that the department has put forward, and it's a multi-factor test. First, they ask whether the directly related to the sale and promotion of the beverage that you're producing in the farm is at least 51% produced from agricultural crops or products grown there. Two, whether it's incidental and subordinate to the retail sale of the beverage on site, meaning the activity must be incidental to your primary business, which is growing wine and producing wine. It has to be hosted by the farm or customers of the farm, not outside or unrelated parties. And for the feature the beverage product on the farm from at least 51% of farm-produced products. So it's a good idea when having these sort of activities to include as much promotion material for your wine and your winery rather than just becoming a generic events venue. That'll help you, and documenting that will help you if this test is ever applied to you, if you're ever challenged as to whether it's truly incidental. Incidental, in addition, the Department of Ag and Markets will look and see if the event sales exceed 30% of the gross sales from retail on site of the beverage produced at the farm at such events. So you have to keep track of what the amount of money you're making for non-wine related activities. Now, what's interesting, if you use if people use like an independent contractor, like a catering company to come in, then it won't be considered against your numbers because you're not receiving the revenue from the catering company. So that's a workaround that I've seen, in certain instances where the winery says, well, it's not me, running the bar. We had a wedding and the catering company came in, catered the event, and who knows what they made? I don't know, but it shouldn't count against my percentage. Whatever money I made was from marketing and selling the wine. Now, obviously, there's a rational limit to this. If you just create an event venue and you have, something catered every night essentially becomes like a sports bar or a wedding venue, and it's not really a winery anymore, you can push that too far, and it ultimately wouldn't, there's situations where that may not be as persuasive. In terms of tastings, farms may market their beverages through a variety of methods, including tastings and food pairings, etc. That's been recognized as legitimate marketing activities by the department. You have to ensure what the primary purpose is, though. You should prominently feature your wine in the location to show that this is really a method to market the wine, that you're not running a tasting business, and it's not your primary business is not charging for tastings. It's marketing the wine that you're trying to sell. Also, it's the department has said that it's helpful for the people working for you, which I think we've all experienced at almost all the wineries in Long Island we go to visit, that the person providing the tastings is knowledgeable about the product and is truly marketing the product. It's not a bartender who's just pouring and doesn't know anything about the wine. There are examples where the Ag and Markets has found that certain activities, though very familiar to us, aren't necessarily incidental to the farm business. For example, the hot air balloon rides, fireworks, pedal carts, the cow train at your local pumpkin patch or apple picking orchard. Those activities, the Department of Ag and Markets has found not to be incidental to the farming, and therefore not enjoying the exemption under the Ag and Markets law, meaning that the town could potentially regulate those activities through zoning. Is a local law reasonable? Well, there have been several cases that talk about the reasonableness of these laws, and you can contact us and we can send you examples if you want. Just given time constraints, I'm not going to be able to go through the facts of all of them here, but first, what I can say is the department goes on to they look at the face of it. Is it reasonable on the face of it? And then they look is it reasonable as applied to a particular situation? So using one example, there was a case called the Matter of the Village of Lacona, the New York Department of Ag and Markets, and that involved the liquefied manure. And a town passed a law that said liquefied manure could not be used, that it triggered their junkyard law. And this product was gathered. There's a spreading case too that they said triggered the junkyard law. And what the Ag and Markets decided and what the court decided was that it occupied the field for the regulations of pesticides and manure and that sort of thing, and the town couldn't regulate that. So they found it to be unreasonable because though they were alleging that there was a public safety concern with groundwater and so forth, the strictness of the law went too far and prevented farmers from spreading manure on their field where there wasn't anything inherently dangerous about that, and it was regulated by the state. They had to get a permit from the state in order to do it, and there were restrictions in that permit that were designed to defend and to protect groundwater. Also, it has to be reasonable as it's applied to a specific situation. So some laws may be reasonable in the face, but as they're applied to an individual winery, it may be unreasonable in the way that people interpret it. This public health exception is the main argument, the main defense that a town or village would employ. So remember, even if the Department of Agriculture and Markets concludes that a particular law or ordinance is unreasonable in the way that it restricts a farm operation, you have to give consideration when crafting your arguments that the town's going to claim that there's a public health or safety justification for it. What are the remedies? So you've made your application to Ag and Markets that a law, either on its face or as applied, is unreasonably restricting a farm operation. What happens next? Well, if you look at the Ag and Markets website, you can actually pull up certain orders where Ag and Markets will issue an order stating an outcome, and that order will be directed at the town. They could choose to do that. In that instance, there are cases that proceed from towns appealing these orders. There's some debate back and forth in the courts as to the the right procedure, because also oftentimes ag and markets, without issuing an order, will launch an Article 78 lawsuit. That's a lawsuit in state court to challenge the validity of a local law or ordinance, and they can do that without going through that order process. So you'll see it both ways, but those are the two primary remedies. Ag and markets is required to initiate actions to prevent the unreasonable restriction of farm operations. They always try to resolve it first to avoid the time and money and inefficiency of litigation. It should be noted that it's not a quick fix. I feel like with the clients that I represent, a lot of farmers talk about ag and markets like this procedure like it's a silver bullet, but it takes a lot of time and money to work your way through that process. It can't be emphasized enough, I think, how important it is to engage on the local level when these laws are being discussed and are being debated. It's much easier to try to influence the passage of a law. It may not be easier, but it's definitely worthwhile to try to influence the passage of a law and make it more acceptable to your farm operation to the degree that you can through the political process, rather than assuming that, well, it obviously is an unreasonable restriction on a farm operation, therefore ag and markets will fix this for me and it'll be all better a month from now. It just takes longer than that, and it may even require ag and markets to, after they've gone through their process, their investigation, they'll send a person out to look at how a law is being applied to a farm operation. After they do all that and issue their order, the town may ignore it, or the town may appeal from that order in court. If the town ignores it, then the ag and markets may have to launch a lawsuit. So it's quite an involved process, and it is important and is a useful protection, but it shouldn't be treated as your only option, and it certainly isn't a quick fix. In a lot of ways, it's a last resort. So I see it is 10:57, and our time is up. I really appreciate your time and attention on a Friday to listen to us talk about it. I know that we've probably touched on many topics that you're interested in and would like to hear more about, and we're available to to talk more outside of this context. Now, I'm seeing as I'm looking at the screen here that there are some questions, and while we have just 2 minutes left here, I want to try to see if we can answer some of the questions. Oh, what is a cow train? Okay, so when I was talking about different sort of retail things that are associated with farm operations, if you've ever been to like a pumpkin patch or an apple picking orchard, there's activities for kids. So that cow train decision that I referenced is where there's a tractor that pulls children along in little vehicles or cars, as an amusement for kids, right? So believe it or not, there's a cow train decision where they said the cow train is not incidental to farm activities, and if the town wanted to regulate the cow train, they could do it. The second question is about incidental use. Is the 30% revenue measured against retail from the winery site only, or is it the wholesale considered as well? Events at the winery encourage both retail and wholesale sales. Yes, I would say you could consider the wholesale sales as well. Also, there was a question at the very beginning about does any of this apply to Christmas tree farms? It does. It's the same law would apply to pumpkin patches and apple orchards and Christmas tree farms. It's all the same ag and markets law that applies to all of them. The same concepts apply. Also, your business may include more than one of these activities. You may do more than one type of crop and more than one type of product, and that doesn't remove the protections of the ag and markets law. I showed you in my slide the specific section that shows that grapes are considered a crop, but that is one of many different kinds of products, and that's listed in the statute. Let me see if there's any other questions that made it onto my window here. I think that's it. So again, I want to thank you for your attention. I want to be respectful of your time and try to end on time here. But if you have any other further questions, please don't hesitate to reach out to us. And Jen, was there anything you wanted to add before we end? I'll let you wrap it up here.
No, I just, again, thank you, everyone. We've got our contact information on the last page there of the slides. Feel free to shoot us an email or give us a call, and hope what we presented today was useful.